now we go to the provisions of the Act first. When we see how this Act is introduced is that an Act to define and limit the powers of certain courts to punish for contempt and to provide procedure therefore. So this Act does not confer the power to punish for contempt, it only defines and limits that power. So where does the power come from? So the power comes from the Constitution of India, Article 129 and 215. Article 129 of the Constitution of India says that the Supreme Court shall be the court of record and shall exercise all the powers of such court, including the power to punish for contempt of itself. And there is same provision for the High Courts under Article 215 of the Constitution. And now court of record and the rest I will go later. Firstly, I'll come back to the provisions of the Act. The section 2, first of all, we must know what the contempt is. It defines the contempt because under the inherent power of the court under 129, it is not defined. The term is too vague, too vast, and it would include just anything. So under law that's not allowed, under a democracy that's not allowed. So for that it was need to define. So it is defined under section 2 of that is the definition clause we know in almost all the acts. So that defines contempt. So it says what is contempt. 2A says that contempt is civil contempt and a criminal contempt. Now 2B says what is civil contempt. Civil contempt is willful disobedience of the order, direction, writ or the process of the court, or willful breach of an undertaking given to the court. So if you have given some undertaking to the court to do or not to do something, and if you do that or you breach that, that is a contempt of court. And secondly, when a court passes an order or a decision or direction, it would have no meaning unless the court has the force, the power to get them implemented. So for that it is very necessary that the courts have their own powers, and that is the civil contempt. Secondly is the criminal contempt. So it is much wider. Section 2C defines. So what it says is that publication through any means, through words, written or spoken, through signs, through visible representation or any other manner, you say anything you may perceive. So publication of any matter or doing of any act that scandalizes or tends to scandalize, lowers or tends to lower the authority of the court. Secondly, it prejudices or interferes with the course of justice with regard to any proceedings in the court of law. And thirdly, it says which interferes with or obstructs or tends to obstruct the administration of justice in any other manner. So first and third are general, and second clause is with regard to the proceedings that may be pending and if you try to interfere with them. Now section 3 to 8, they contain the defenses, and 13 also, defenses to the action for contempt under the Contempt of Courts Act. Now section 3 says that if a person, some innocent publication and distribution of a matter that is protected, that if someone publishes a matter through any means that interferes or tends to interfere or obstructs or tends to obstruct with the course of any judicial proceeding that is pending in the court, that would not amount to contempt if the person so publishing had no reasonable ground of believing at the time of publication that any such proceeding was pending. Secondly, if any such matter is published, but at the time the matter is published, no such proceeding is pending, even that would not amount to contempt of court. And third clause says of section 3 that distribution of any such matter, which is discussed in clause 1 and 2, that would not amount to contempt of court if the person so distributing the matter had no reasonable ground to believe that it contained any such matter. So this is section 3, but the protection would not be available if the publication is not in conformity or it is in contravention of the provisions of Press and Registration of Books Act 1867. Now we go to section 4. Section 4 says that a fair and accurate reporting of judicial proceeding does not amount to contempt of court, because proceedings of the court are they are recorded and they are published. We see in the newspapers even what judges say, what advocates say, or what orders are made. So if it is fair and accurate, that does not amount to contempt. And section 7 says even the proceedings that are in chambers or in camera. In camera means in private, and in chambers is in the office. Chamber is the office of the judge and not the open court. So if in the office of in chambers or in camera the proceedings take place, that is fairly and accurately reported, even that would not amount to contempt of court, provided it has not specifically been prohibited by some enactment, or the court, in the interest of some public policy, it prohibits the publication of such proceedings or orders that may be made by the court. So this is 7. Then we come to section 5. Section 5 says that after a matter has been disposed of, finally, fair criticism of the judicial proceedings or the order on merits of the case. So that would not amount to contempt of court. So you have right to criticize on merits. It should be bona fide. It should not be with some malice, or you should avoid imputing some wrong to the judges. So if you are fairly criticizing, you are allowed. And then is section 6, which says that if a complaint is made against the presiding officer of a subordinate court before some other subordinate court or before the high court to which that subordinate court is under which it falls, and that would not amount to contempt. And section 8 says that all the defenses that are otherwise available in proceedings against contempt would not be unavailable. They would not cease to be available merely because of the provisions of this act. And section 9 says that this act does not enlarge the scope of the contempt, the power of the court to punish for contempt. Section 13 I was talking about. 13 in 2006 it was amended and clause 2 was added. It says that courts may allow justification by truth as a valid defense in proceedings for contempt. So earlier even truth was not allowed as a defense. So there was much criticism. So now, if it is bona fide, if the request is bona fide, then courts may allow the justification, but to prove that whatever the allegations you are making, they are based on truth. So that may be allowed as a valid defense. Then there is clause A of section 13, that was there in the original act. It says that the courts will not impose a sentence normally unless the act alleged to be contempt substantially interferes with the course of justice. So courts must be very restrictive, very sparingly, they say they should use this power of contempt, because this is a grave power. And then is the section 10. Section 10 says the power of the High Court to punish for its contempt is it can punish for its contempt as much as it can punish for the contempt of the subordinate courts. And 11 says that there is no restriction of territorial jurisdiction. So the contemner may be within or outside the jurisdiction of the High Court. Court can punish for its contempt as well as of the contempt of the subordinate court, but in case of subordinate courts, High Court would not punish if the offence is punishable under the Indian Penal Code. And then 12 is the punishment. The punishment is it's simple imprisonment, the maximum, for 6 months, and a fine that would not be more than rupees 2,000. And it's the discretion of the court. Court may discharge, court may accept the apology if it is bona fide, or court may punish. Now is the section 14. 14 says that if contempt is committed in presence on a hearing of the court, like it happens many a times that, not many a times, a few times it happens that in the presence of the court some insults are hurled, or unbecoming conduct, improper conduct is shown that is not that hurts the decorum and dignity of the court. The court has the right to detain the person then and there, and after informing him of the contempt proceedings and allowing him time to defend and to have a legal assistance. And then he also has a right to plead before CJ that the contempt proceedings be proceeded be taken up by some other bench. So that is also available to the contemner. And section 15 says cognizance, who has the right to take cognizance of the contempt of court. So the court, High Court or the Supreme Court, may take suo motu action on its own motion, or on a motion moved by the Advocate General in case of High Courts, or in case of Supreme Court, the Attorney General or the Solicitor General of India, and any other person, but with the consent of the Advocate General. So for a common citizen to move court for contempt of court against any person, you have to get the consent, the approval from the Advocate General or the Attorney General in case of Supreme Court. Now in case the Advocate General does not grant permission or does not approve that such contempt be filed before the court, petition be moved before the court, this decision of the Attorney General is not reviewable. Supreme Court has held that the Advocate General, he acts as an amicus curiae of the court. So he is not acting in a quasi-judicial authority with powers. So it is he assists the court and to save the time of the court, because there are many petitions that are filed they want to be filed. So he scrutinizes those, and he would present only that petition which he seems is worthy of being presented before the court. So his decision is not reviewable, and the person, any individual, has right to place the information before the court, and court would take suo motu action. So this is about 15. And in case of high courts, in case of subordinate courts, a reference may be made by the subordinate court to the high court to take up the contempt, or advocate general may move the high court. So that's about the cognizance. Then we come to section 16. It says that the contempt of court law is applicable to any judicial officer, any judge, or any other person acting in judicial capacity as much in the similar manner as it is available, as it applies to any other individual. So there is no laxity on that, because decorum and dignity of court is to be maintained. Then 17 talks about the procedure. It's normal due process, as we say. The notice is served, then allowed defense, evidence, and then, but it is proceeded in a summary manner that is allowed. So then 18 says that in case of criminal contempt, it is to be heard by a bench of not less than 2 judges. And 19 says that appeal is allowed as normal course from single bench to DB within 30 days, and from DB of the High Court to the Supreme Court within 60 days. And 20 says that within a period of 1 year from the date of the alleged contempt that is committed, within a period of 1 year, this contempt proceedings should be initiated. If it is not, then thereafter it is not allowed. And 23 grants the powers to the Supreme Court and the High Court to make rules. So Supreme Court has its own rules under the Contempt Act, and each High Court has framed its own rules. So that is in brief about the Act. Now I'll come back to the article